Good evening. Welcome to Karamah, where Karamah, Muslim women lawyers for human rights. Karamah means dignity. Our mission is to promote and advance the rights of Muslim women within their faith perspective through education and research. And as part of that mission, we're here to educate about the various issues that affect the Muslim American community, specifically Muslim women also. Actually, first, before we begin, I hope you all had a time to enjoy the light fare in the back, so I hope you had some snacks. And please, if you can, I guess turn off cell phones and keep them on vibrate if you can. And watch out for the wires. We got some videos in the background. We don't want anyone tripping. The lawyer speak coming out here. Thank you again for joining us this evening. As part of my mission, this is our second round of having a lecture series, so I see some familiar faces, which I'm very happy that you have been able to come this evening and dedicate your time to learning more about the constitutional pitfalls of material support laws. And tonight we have a distinguished panel, and I'm so honored and pleased to present to the panel. Specifically, we've been working with the Constitution Project and the Terrorist Institutions Network, specifically the Constitution Project, for over 2 to 3 months now, and making this event possible and discussing this issue that is very important to the Muslim American community, that's enabling them to provide zakat giving freely within the rights that are prescribed here. So, of course, I will leave Sharon B. Franklin to introduce the panel, and so we're going to have basically discussions from the distinguished panelists, and we'll have time for Q&A. And anyone who's requested CLEs, I'm pretty sure there's some folks who are trying to get their credits before the deadline. Please see Mr. Eugene Hummel. Hummel, you want to raise your hand?
Over here.
And we'd love to tell you a little bit more about Karamah and the work we do and the programs and the educational initiatives that we have. So we did have a little trifold for you that gives you a little information about ourselves. And if you have any questions, feel free to reach us. I'd like to take the time to thank everyone that has helped us make this event possible, all the Constitution Project interns and staff, in addition to specifically the Karamah team. Some of our members are here, Ms. Naveen Abdullah, who's our Director of Research in the back, and Ms. Susan Riker, who's our Director of Development and Communications, and also the rest of our communication team, Ms. Hannah White in the back. And I'm pretty sure you met our lovely staff downstairs. Thank you very much. I hope you enjoy the panel.
Thank you very much, Maze. I'm Sharon Bradford Franklin, Senior Counsel with the Constitution Project, and I want to thank Karamah for inviting us to co-sponsor today's program with them. Constitution Project, for those of you not familiar with us, is a nonprofit organization based here in Washington, D.C., whose mission is to promote constitutional safeguards. And we have both a criminal justice program and a rule of law program. And through both of those programs, we pull people together from across the political spectrum, and people with a variety of areas of expertise, different backgrounds, and we work with them to develop consensus-based recommendations for policy reforms that do promote constitutional safeguards. Most relevant to our program here today is the work of our Liberty and Security Committee, which was formed in the aftermath of September 11th and works to ensure that we promote both our national security and our civil liberties. Now, our panel here today is entitled Constitutional Pitfalls of Material Support Laws. And our focus will be mostly on those constitutional pitfalls, but I want to talk just very briefly a little bit about the material support laws themselves. I don't want you to walk away with the impression that the material support laws are actually all bad, because they're not. These U.S. laws make it criminal to provide material support to groups that are designated as foreign terrorist organizations. And they serve a very important purpose. They ensure that our government can not only prosecute the terrorists themselves, but also the people who aid and abet acts of terrorism and make those acts of terrorism possible. And so they are, in many ways, the principal statutes that the government relies on in prosecuting terrorist crimes and suspected terrorists. So when we come here today to talk about constitutional pitfalls, groups like the Constitution Project aren't calling for a repeal of the material support laws. We're calling for reform, and similarly with a lot of the other advocacy groups that we work with. The Constitution Project became involved in these issues directly through our Liberty and Security Committee. And in the fall of 2009, we released a report entitled Reforming the Material Support Laws, Constitutional Concerns Presented by the Prohibitions on Material Support to Terrorist Organizations. and hopefully you've had a chance to pick up a copy of that report downstairs. In this report, our committee notes that while, quote, cutting off support of terrorist activity is an important and legitimate part of the United States counterterrorism strategy, the existing laws on material support raise serious constitutional concerns under the First, Fourth, and Fifth Amendments. Now, I'm not going to delineate them all here today, but the report does go through 8 specific recommendations for reform. And broadly speaking, they fall into and cover 2 different categories of constitutional concerns that will be the focus of our panelists here this evening. First are problems under the First Amendment. And the material support laws extend beyond punishing just conduct that supports terrorist activity and broadly prohibit various types of aid that humanitarian groups and peace-building groups try to provide, such as training groups to use peaceful tactics. And groups like the Constitution Project feel that this violates the First Amendment. The Supreme Court, as you'll hear a little bit more from David Cole, didn't quite agree entirely, but there are still some issues, important issues that we need to discuss. The second broad category are due process and Fourth Amendment concerns. And this is where if a group is accused of being a foreign terrorist organization, there are almost no procedural protections in place for them to challenge that designation and say, no, you got it wrong, not our group. And also the law allows for seizure of assets without any demonstration of probable cause. So our panelists are going to talk about these 2 broad areas of constitutional concern, including the current status of litigation, the direct impact on charities and people who seek to donate to them, and reform efforts that are underway in the advocacy community. And so I want to introduce our panelists and lay out a little bit how we're going to proceed. First, Professor David Cole will provide an overview of the material support laws and the constitutional challenges in the courts to the scope and operation of these laws. Professor Cole is a professor of law at Georgetown University Law Center, specializing in constitutional law, national security law, and criminal justice. He was lead counsel in the U.S. Supreme Court in Holder versus Humanitarian Law Project, and he's also litigated numerous other cases involving the material support laws. And importantly, he is co-chair of the Constitution Project's Liberty and Security Committee. Next, Dr. Azizah al-Hibri will discuss the impact of the current restrictions, particularly on the Muslim community and those seeking to meet their zakat obligations. Dr. al-Hibri is the founder and chair of Karamah, and she is also a professor at the T.C. Williams School of Law at the University of Richmond. She has traveled to over 13 Muslim communities to speak and share her expertise and has written extensively on issues of Islam and democracy. And she is actually a member of our Liberty and Security Committee. Finally, Guinane will describe additional examples of the impact of the laws for charities and explain some of the reform efforts that are currently underway among advocacy groups. She is the program manager of the Charity Security Network, a project aimed at bringing down barriers to legitimate work of nonprofits from ill-advised national security measures. And previously, she was director of nonprofit speech rights at OMB Watch, which is a watchdog organization in D.C. After these opening presentations, I'll moderate a discussion among our panelists, and then I will open it up for Q&A with you, the audience. So with that, I'd like to turn it over to Professor Cole.
All right, thanks, Sharon, and thanks to Karamah for having me here. I'm here mainly because I lost the Holder versus Humanitarian Law Project case. It's not something I like to do, to talk about cases that I lost, but these days, if I didn't talk about cases that I lost, what would I talk? So I think the best way to understand this material support regime is by thinking back to the last sort of period of significant national security crisis and fear, and that is the McCarthy era. And in the McCarthy era, the concern was communism. Congress made findings that the Communist Party was an international conspiracy engaged in terrorism and other illegal acts with the purpose of overthrowing the United States by force and violence. And we then essentially empowered the federal government to designate proscribed communist-affiliated groups through a secret process within the executive branch. And then punish people, either by taking away their jobs or by denying them national security clearances or by prosecuting them for their affiliation, association, or support of the Communist Party or these affiliated groups. And in the course of that, many people who were affiliated with communist groups or communist affiliated groups, but not engaged in any kind of illegal activities, lost their jobs, lost their clearances, went to jail, etc., etc. Ultimately, and ultimately was a long time, the Supreme Court ruled in the waning days of the McCarthy era, only after Joe McCarthy was censored by the Senate for going too far and going after the army for harboring communists, the Supreme Court ruled that that was unconstitutional, that you can't punish people for supporting or associating with a group that engages in terrorism simply because they're supporting or affiliated with that group. You have to show some nexus between their affiliation, their activities, and the illegal acts of the Communist Party. So people who are working with the Communist Party for its labor organizing, or working with the Communist Party in its civil rights activism, it was very, very active on civil rights, race issues here in the United States, they can't be punished. People who are working with it to further its terrorist ends of overthrowing the United States by force and violence, they can be punished. That was the line the Supreme Court said was required by the First Amendment and by the Fifth Amendment. Well, I think the material support laws are a 21st century reincarnation of that approach. Today, the fear is not communism, it's terrorism. But as then, Congress makes findings. The finding here is even more sort of vague, and it's that terrorist organizations, unidentified by their nature, are so tainted that any support to them it furthers their illegal ends and therefore should be made a crime. Not a finding as to any particular group, but just a statement about terrorist organizations in general. We then give the executive branch virtually carte blanche to designate groups as terrorists, using either extremely broad statutory criteria, in which the government is allowed to designate any foreign group that has ever used or threatened to use violence, whose activities threaten the foreign policy of the United States, a determination that courts can't review. They get put on a list. The list is created in secret. It can be based on secret evidence. The entities that are put on the list are not told, given notice of why they're being put on the list. They are given an opportunity to defend themselves, but without even knowing what's at issue with respect to their conduct, and no group has successfully defended itself under this process. Once a group is on that list, and there are two lists, one the Treasury Department maintains that has about 10,000 individuals and groups on it, and another the State Department maintains that has about 40 groups on it. But once a group or individual is on that list, it then becomes a crime for anyone to provide that individual or group with any kind of material support, regardless of the intent, regardless of whether it's furthering illegal or legal activities, regardless of whether it constitutes speech or not. So we brought a lawsuit challenging this law about a decade ago on behalf of the Humanitarian Law Project, the human rights group in the United States that had been working with the Kurds in Turkey and encouraging them to resolve their disputes with the Turkish government through peaceful, nonviolent means, specifically helping them bring human rights claims in Geneva, helping them with peacemaking overtures to the Turkish government. When this law was enacted and the Kurdistan Workers' Party, the Kurdish group with which my clients had been working, was designated as a terrorist group, it then became a crime for my clients to continue to provide this kind of assistance. Why? Because material support is defined to include not only giving money, writing checks, but also any service of any kind, which the government defines as anything that is of benefit to the group, any personnel who's doing anything under the group's direction or control in coordination with the group, any expert advice or assistance, and any training. So training them in how to bring human rights claims, providing expert advice on peacemaking, working to advance their peaceful, nonviolent interests, all of that constitutes a prohibited material support, which is a felony, punishable by 15 years in prison for each act of such support. Our argument was that our clients are engaged in speech. Not only that, they're engaged in speech that is designed to further only lawful, nonviolent ends. Doesn't advocate any kind of crime. The Supreme Court has said in the past that even speech that advocates crime is constitutionally protected, except where it is intended and likely to produce an imminent crime. So you can get out there and say, you know, I think terrorism is a great idea. I think we should kill innocent civilians. That's perfectly protected, unless it is intended and likely to cause imminent lawless violence. Well, our claim was, look, our clients are trying to discourage resort to violence. They're working for peace and human rights. They're advocating lawful, nonviolent means. Surely that kind of speech cannot be criminalized. The government's argument was, yes, it can. And the reason it can is that anything you do that supports these groups in any way, we want to prohibit. We want to make these groups radioactive, the government argued in the lower courts. And therefore, we don't care whether what you're doing is legitimate or illegitimate. We don't care. We just want to cut them off. So much so that they said, in both the lower court and the Supreme Court, writing an amicus brief on behalf of one of these groups in the Supreme Court would be a crime. And we thought that was a pretty extreme position, and we thought we had a pretty good shot at winning. The government's sort of legal theory was this was okay because they weren't actually regulating speech at all. What they were doing was prohibiting conduct, and they don't care how the support, whether the support comes in the form of dollars or speech, and therefore they said the court should treat this as a regulation of conduct. The court treats regulations of conduct very deferentially, does not apply very stringent scrutiny. We said, no, when the conduct of support that you're making it a crime to engage in is using words to tell people how to bring a human rights claim in Geneva, that's a regulation of speech. And regulations of speech are traditionally subject to strict scrutiny, under which the plaintiff virtually always wins. Well, on that issue, I'm proud to say we won. All 9 justices agreed this was a regulation of speech. It had to satisfy strict scrutiny, and in an ordinary case that would mean we won, but this was not the ordinary case. And the court went on to say that in this case the government satisfied strict scrutiny. The government never satisfies strict scrutiny, but in this case the government satisfied strict scrutiny. So how did it satisfy strict scrutiny? What's strict scrutiny, for those of you who aren't lawyers, or forget their con law, strict scrutiny requires the government to posit a compelling government interest. That's easy, fighting terrorism. But they also have to show that these means, prohibiting this kind of speech, is necessary. It is the most narrowly tailored means necessary to further the compelling state interest. So why is it necessary in fighting terrorism to make it a crime to advocate for peace? Well, Justice Roberts had 3 reasons. First, he said, if you teach them how to bring human rights complaints, they might bring those human rights complaints for purposes of harassment. To which my response was, well, I think we'd rather have terrorist groups filing harassing human rights complaints than killing innocent civilians. The second argument was, well, if you work with them on how to negotiate for peace, they might use that as a delay tactic to rearm themselves to engage in further terrorist acts. Well, they might, but that would suggest that the State Department should go out of business as well. The third argument, and this is the broadest argument, the third argument was that even if these activities have none of those effects, by working with the group on lawful, nonviolent things, you give the group legitimacy. And when you give the group legitimacy, it can then go out on the open market and use that legitimacy to raise more money to kill more innocent civilians. Of extremely broad rationale. And therefore, the court said, it's constitutional to make it a crime to advocate for peace and human rights. Now, the sort of consequences of this, one is from the standpoint of First Amendment doctrine, it's a very dangerous notion that the government can say, we've identified a group, we want to delegitimate the group, and therefore, and that interest, according to the court, is a compelling interest that justifies us in making it a crime to do anything that legitimates the group. It's a very broad argument. That argument would have required the opposite result in all the Communist Party cases, because working with the Communist Party on labor organizing and civil rights legitimated the Communist Party. So if that were a sufficient rationale, all of those cases would have come out the other way. It's a very, very dangerous and broad rationale that I think could have very disturbing consequences for freedom of association and speech in time to come. More specifically, the decision jeopardizes very important work, peace work and humanitarian aid work. It makes clear that there is no constitutional protection for those who are working for peace. So it means that when Jimmy Carter's Carter Center goes into the West Bank and works with Hamas and the Israelis to try to further peace, and they provide expert advice in peacemaking, they're engaged in a crime. It means that when Jimmy Carter's group went to Lebanon to monitor the elections there, and as a part of their monitoring elections, they had to meet with all the parties to the election, including Hezbollah, because Hezbollah is one of the parties to the election, they violated the law because they provided expert advice based on their election monitoring on what's a free and fair election to Hezbollah, which is a terrorist group identified on this list. It means that when the New York Times publishes an op-ed by a Hamas leader and works with him on editing, etc., the result, and then publishes the result, they've provided a service to Hamas and violated the law. It means that when Michael Mukasey recently went to Paris and spoke out on behalf of the MEK, an Iranian opposition group that is on the list, he violated the law. The former Attorney General violated the law by advocating, engaging in public relations, providing his services in support of the MEK. It's a very, very expansive law, and my sense is that Congress did not intentionally want to make Jimmy Carter and Michael Mukasey in the New York Times into terrorist criminals. Now, Michael Mukasey, Jimmy Carter, and the New York Times will not be prosecuted because they are Michael Mukasey, Jimmy Carter, and the New York Times. They don't need to worry about it. It's Muslim groups that need to worry about it. But the principle is nonetheless a very, very dangerous principle, and one that I think there's some chance that Congress might rethink if it sort of confronted this extreme circumstances, extreme applications of the law. So my hope is that we can now work through the executive branch and through the legislature and through public advocacy more generally to try to bring some reason to this law, to introduce some constraints to the law, whether they be through executive regulation or through legislation, that carve out some of the kinds of work that I think all of us recognize are important. Working for peace, working for human rights, providing humanitarian aid to people in times of conflict and need. Those sorts of things should not be treated as terrorist crimes. We don't need to treat them as terrorist crimes in order to fight terrorism in an effective way. And if we continue to do so, we are running counter to the very traditions that ultimately said the Communist Party laws were unconstitutional. The last thing I'll say is that the victories in the Communist Party cases took a long time, and they followed some early significant defeats. So this is a long struggle. It's by no means over, but it requires people learning about, being educated about the consequences of this law, objecting to the consequences of this law, and advocating and organizing for change. Thank you.
Before
before focusing on this particular issue, I'd like to put it in context. The issue of the treatment of Islam in this country goes beyond and much earlier than 9/11. And I don't mean to go back to the 1990s. I mean to go back to the 1600s. At the time that this country was still being formed, even in Jefferson's days. At that time, the problems we saw related more to the Africans who were brought from Africa through the slave trade into the United States, and many of them were Muslims, and many of them were not permitted to actually exercise their religion when they came here. Actually, the situation was quite extreme. I didn't realize how extreme it was, but in my research, I located families, African-American families in the U.S. who said that their families, until the turn of the last century, in the early 1900s, they still would not say publicly that they were Muslim. They started relaxing after that. Things were starting to get a little bit better, especially with the civil rights movement and all sorts of opening of the American community, society. And then what we see now is a focus more on the immigrant wing of the Muslim community. And again, this is not something that happened after 9/11 either. In fact, I remember that I talked about the use of secret evidence with President Clinton in the White House. It was something that preceded, for example, the late Bush administration. And it all started a development in which Islam was being mixed up with politics. And we started hearing phrases like political Islam. You know, I don't hear that with respect to other religions or the Islamic nuclear bomb. You know, so we started having very weird associations of the religion with some really serious political adjectives. And that was early on in the 1980s or 90s. And at that time I started thinking, if we continue down this road, then this is just a preface to starting to restrict Muslim liberties in this country on the basis of security. And to justify it that way and sort of get us out of the protection of the First Amendment and other items. And sure enough, things started happening. There were cases that my colleague here was involved in before 9/11. But also after 9/11, if some of you remember, and I know there are old faces and faces of old friends in the audience of Karamah. No, young faces who are old friends. And these people probably came to our town hall meeting after 9/11, in which we held a panel just for Muslim women who were traumatized by the raids in Virginia in 2002, I believe, in March. These were wives and daughters whose homes and also the workplace was raided, and their computers and other things were confiscated for some sort of an investigation. We don't know what. Some secret evidence. We don't know what. A very promising educational institution could no longer function because it didn't have its records. The computers just migrated. It couldn't tell even who graduated from that institution and so on. Well, we thought, you know, maybe the Muslims should grin and bear it for a while. It was right after 9/11, and of course we are interested in the security of this country as well. We are Americans. And that's the point you make very clearly. We'd like a balance. That kind of investigation continued and continued and continued. Nothing was happening. So there were some good, outstanding citizens in our community who were under a cloud of suspicion, good institutions under a cloud of suspicion, and we couldn't know whether we should deal with them or not. So they were, in effect, excommunicated by many of us, because no one wanted the risk. And not only did we not want the risk, of having to deal with them. I remember, for example, some of them gave us, checks for Karamah to support us. I did not cash those checks because I had no idea what was going to happen later. And I had a feeling that there will be this retroactive kind of look that we can talk about later about who we associate with. I will tell you something that might shock you, but in the Clinton days already, we were talking with the civil rights division person from the Justice Department about the fears of the community, that there is actually in place preparations to do to them what this country did to the Japanese. That they are going to go into camps away from their home. And there was real discussion in the Muslim community. Is this going to happen? How could they put millions of people in a camp? Probably that is not feasible. Probably that's not going to happen. But then the documents surfaced and we didn't know if they were real or forged. Everybody was talking about that, even in the Clinton days. But what happened today is that the Muslims have not been corralled together in one place in a camp. Rather, each one of us have our own private prison. And that prison is in our head. We've been told what could happen to us if we go outside this limit. And it is really a very serious situation because we do not feel as free in this democracy as the other American citizens. That means we don't feel equal citizens. Let me give you a couple of examples so that you don't think we're exaggerating. At one point, historically, one country in the Muslim world experienced an earthquake, which resulted in floods and a great deal of destruction to the capital. A lot of schools were destroyed, etc. And somebody, from the diplomatic corps of that country, and some diplomats come and attend our functions, suggested that maybe Karamah could do a gesture. And we said, sure. So we decided, why couldn't we, our gesture would be to prepare a lot of backpacks with pencils and erasers and, toy-looking things for the children who have lost so much. And so could we do that at Karamah? And I, in particular, called the Justice Department and talked to the Civil Rights Division about this issue. And I said, if Karamah does that, because, we are just trying to help the children, and these people are allies of the U.S. That country, by the way, it was not a country that was suspicious to our State Department. Could we do that? And he said, of course you could do that. What idiot is going to think that giving a backpack to a child is supporting terrorism? And I said, well, I'm so glad you said that. Could we have a letter? And he said, sure, give me some time. And time passed, and time passed, and time passed, and there was no letter. So let me give you another example. This time it was Pakistan. They again had earthquakes and floods and disasters. And we thought, okay, we're not going to send backpacks. What are we going to do? Because there are some Pakistani Americans in our community who really would like to do something for their country of origin, could we just go counsel these women who are sitting, among the rocks in the cold, hungry? Could we just counsel them, hold their hands? Oh yeah, you could. Okay, could we have a letter? No. We can't have a letter. You know why? Because before I can hold her hand, I really have to do a thorough investigation, a due diligence investigation, to make sure there's nobody in her family who is a terrorist, like maybe a great-grandfather or a nephew or God knows who. I don't know. So if I go to help this woman, I'm taking my own freedom in this country in my own hands. I cannot help a sister abroad. By the way, anybody else non-Muslim in this country can, because they are not under suspicion like I am. That fragments the Muslim community, not only within the United States, but between the United States and internationally. So when we hear from the various administrations that we American Muslims, could play the role as a bridge between this country and the other countries, so that we can smooth the development, so that we can have democracies like we're seeing now, the spontaneous wave in the Muslim world for democracy, when we are being asked to be a bridge, when there is a whole public diplomacy program in the State Department about this, when I was taken to God knows how many countries in the Muslim world to speak to them about democracy and women's rights by the State Department. Now I'm thinking, oh my God, how could I possibly talk to them? I don't know who's in the audience, right? So what kind of due diligence can I conduct to make sure that it'll be okay to talk to that audience? Now you're going to tell me, but the law has the word knowingly. You know, if you do something knowingly, except in the discussion we find out that that is not a very effective protection, as it turns out, unfortunately. So these are really very serious aspects of our existence in the United States. Recently, some of these individuals or organizations under a cloud were told, okay, we've dropped the case. We're done. Okay, could we have a letter which says we're okay? No. We just dropped the case. Okay, I still can't work with that. I still don't know when our government is going to go back and say, you know what? We didn't get it the first time right, but now we have evidence or whatever. I mean, what am I to do? Why is it that we could not ask for certain protections? I talked to President Bush about this, and I asked if we could have a good faith exception. You know, if we've really done our due diligence, if we're not showing gross disregard or negligence in our relationship with others to determine whether they are terrorists or not, if we are just trying to do what other decent Americans are trying to do, why couldn't that be possible? And it was in part in response to this demand that the president formed, and he told me that he had formed this committee at the Treasury to devise the guidelines of the Treasury. And the next time I saw him, which was a year later, he said, did you see the list? That list was being released that night. I said, I didn't see the guidelines yet. So I went and saw them. Well, very nice guidelines, but at the end it says, but that's not all, folks. So there is still a possibility that you could do all of the above and you'd be unlucky. So I still have my worries. What I'd like to be is an American with the full rights and privileges of every other citizen. And no one in this country may take this away from me or my Muslim compatriots. The problem we've had in the Muslim community is that for the longest time, many of our young generation did not go into law. And so when this came up down the pipe, and I did testify at the hearing of the Anti-Terrorism and Death Penalty Act and pointed out to some of these problems, there was no strong Muslim voice, because there was no strong understanding of what this might happen, no strong legal understanding, although they always had the intuition. Now, we have a lot of lawyers who are Muslim, who came out of American law schools, but it will take a while before they can become more active in the community. We are very thankful for decent Americans who are concerned about their co-citizens, like Professor Cole, who have spent a lot of time defending our constitutional rights, but also we need to stand up and fight for that. And it's time to stop accepting this demonization of Islam, which you see in the media and elsewhere. And the question becomes, how do you do it? And that's a whole other discussion.
Thank you. I'm Kay Guinane. I coordinate the Charity and Security Network, which is an advocacy campaign and collaboration of a broad cross-section of U.S. charities, grant makers, peace-building organizations, development, human rights, civil liberties groups. It includes Muslim charities and some allies in the charitable sectors in Canada and some of our other other countries or civil society, I guess, is something that doesn't necessarily have national borders. I think because I get to talk about reform and how to fix these problems, so I think I have the fun part tonight, and hopefully you'll be less depressed. And you see that this can be fixed, and there are some guiding principles that are long established that we can incorporate to guide sensible reforms in this area. I think a starting point is to make sure that the policymakers and the public understand when the Supreme Court upheld the constitutionality of the law, they didn't say the law has to be this way. They said if Congress wants it to be this way, it can get away with it. But they gave an extreme level of deference to the executive and legislative branches, which means that these other two branches of government have a very grave and serious responsibility to look at this policy and make sure they get it right. And getting it right means two things. It should be based on facts and evidence, not on myths or hypothetical scenarios of the type that were raised in the Justice Roberts' opinion that David described. And it also needs to be consistent with well-established human rights and international humanitarian obligations. And I refer in part to the Geneva Conventions, which we are signatory to and as a nation obligated to comply with. There are several potential paths to reform. It could happen in a variety of ways, but first it's important that however it's approached, that policymakers embrace a set of core principles that guide whatever legal vehicle we tackle for reform. There's a handout that lists the Charity Security Network 10 principles for reform. But the key thing is that humanitarian aid to civilians, non-combatants, should be legal, even if it requires contact or coordination with a designated terrorist group to get access to those people. In other words, we have to distinguish between aid to terrorists and aid to people who are in areas they control or subject to attack by them. So that you don't have the example, Save the Children was not allowed to drill a well in a village in Somalia that was threatened with famine because someone from al-Shabaab might come through the village and get a drink. Or the example that was given about going to Pakistan to counsel these women, the other principle of aid has to be non-discriminatory. International humanitarian law demands that, and the material support law is inconsistent with that. It doesn't matter if someone's family member is a member of a terrorist organization. For them, it doesn't fit into a humanitarian aid calculation. The orphan of a suicide bomber is equally hungry as the orphan of someone who dies from a heart attack and equally eligible for humanitarian aid. So bringing those core principles, long-established principles, back into our consciousness is something we need to do to drive our reforms. The next thing is just common sense peace building should be legal. We don't want to threaten people with jail terms for trying to get organizations to lay down their arms. And that's, I'm not going to belabor that because it just seems, they say, self-evident. Thomas Jefferson would say. And the next thing, in terms of free speech, human rights advocacy and solidarity work with people in other parts of the world who are trying to organize and assert their political and human rights, that's not supporting terrorism. And we have a fuzzy line that's been created after the Humanitarian Law Project decision, where now there are organizations in Chicago and Minneapolis that are being investigated by a grand jury for doing solidarity work with organizations in the Palestinian territories because they're accused, apparently, that that's equal of supporting Hamas by supporting human rights for Palestinians, mean that the U.S. attorney there thinks they're violating the material support statute, that we need to separate those things. The other principle is that reform needs to address what this was called the entire chain of charity, from the donation through the operational charity down to the rights of the ultimate civilian non-combatant beneficiary, because their needs are what it's all about. So some of the government agencies that want to maintain the status quo try to limit the discussion to the fact that there's an issue with donors, but they haven't prosecuted any U.S. donors, therefore there's no problem, and we should just calm down and go home. So they're ignoring the entire chain, and especially the impact on the beneficiaries, which is really what this whole effort is about. Check my time. So implementing these in U.S. law, there are a variety of vehicles that can be used. The strongest ones, of course, are the ones that would change the law itself, so that these standards aren't subject to the whim of whoever happens to be holding office. To just have an administration say, we're going to shift policy for now and not use these excessive powers is not good enough, because they could change their mind at any time. The powers could be abused or used in a discriminatory manner, or another administration come in and take a different view. So that for rule of law reasons, these reforms need to be written in to the law so they can be enforced, and so that we can rely on them and know what they are. That can happen best by Congress amending the material support statute itself to broaden the humanitarian exemption, which right now only applies to medicine and religious materials. So it's legal to give someone a pill under this, but not legal to give them the water to swallow the pill, not legal to provide the medical services to diagnose which pill they need. So we need to expand that exemption and make it clear that the purpose of this is to give aid to civilians, to non-combatants. So it should include the things that Geneva Conventions recognizes: care of the wounded and sick, supplies essential to survival, foodstuffs, shelter, clothing, repair and restoration of infrastructure, education of children, communications between family members, or attempts to rescue child soldiers and civilian hostages and detainees. The law should clearly permit peace-building efforts by organizations that are designed to train and convince terrorist organizations to lay down their arms, and clarify that political advocacy, human rights, and solidarity work are protected under the First Amendment. We also need to amend the International Emergency Economic Powers Act, which has kind of a reinforcing effect on the material support law, because it makes it a crime to have any kind of transaction with a group on the list, and that can get you shut down under a whole other regulatory scheme. There needs to be due process for individuals and entities in the U.S. or with U.S. presence who the government wants to put on the list, so that you can have notice of what the reasons are, the opportunity to confront the evidence against you, and independent review of the government decision, none of which we have now, and which has process been declared unconstitutional by 2 federal courts. There needs to be periodic review of designations as well. If Congress doesn't want to do this right away, the administration at the next level could issue a new executive order that would replace executive orders 13224 and 12947, which one under Bush and one under Clinton, that could implement these basic concepts of due process, clear standards, and humanitarian principles with our material support laws. The UN Human Rights Council issued a report in December that said regular review and the use of sunset clauses are best practices, helping to ensure that special powers relating to the countering of terrorism are effective and continue to be required, and to help avoid the normalization or de facto permanent existence of extraordinary measures. We are now approaching the 10th anniversary of 9/11, and we have a host of so-called emergency measures that seem to be becoming permanent, and so this is a good time for the administration to look at a new executive order. Lastly, regulatory change. Treasury, State, Department of Justice can all issue by regulation under current law procedures and standards that would comply with all of the principles that I've laid out. In particular, the State Department under the material support law, has the power to exempt training, expert advice and assistance services in situations where the Secretary would make a determination the activity would not present a threat to national security. So tomorrow, Secretary Clinton could issue an exemption that would allow the peace-building activities of U.S. and other organizations to go forward. Right now, we're hearing many stories about peace-building efforts that are going without resources, or negotiations that had to be canceled because of the impact of this law. So that's something that could be done right away. And then I think the last, in terms of the Justice Department, needs to instruct the FBI and the U.S. attorneys that First Amendment free speech activity is not material support, and make that clarification.
Thank you. Okay, so I want to start the back and forth here by a specific question for each of our panelists. So I'll start with David here. You spoke a fair amount, thank you, about the Humanitarian Law Project case, but in terms of groups trying to figure out in the aftermath and how to protect themselves and what some of the perils are, could you also talk a little bit about the Holy Land Foundation case and some of the due process problems that we're seeing there?
Sure. The Holy Land Foundation case, which some of you may be familiar with, was a criminal case that arose out of allegations of support to a terrorist organization. The Holy Land Foundation was the largest Muslim charity in the United States. It was shut down under the International Emergency Economic Powers Act shortly after 9/11, largely on the basis of secret evidence. Ultimately, many years later, the U.S. Attorney in Texas brought criminal charges against the board members of the Holy Land Foundation. And what's particularly disturbing about the Holy Land Foundation case is that they were prosecuted and in a situation where the government does not identify a penny that actually went to Hamas or to any designated group. The argument, rather, is Holy Land Foundation provided charitable assistance to local charity committees, zakat committees, in various communities in the West Bank and Gaza. Those committees were not designated, are not today designated, but the government came into court and said, well, we didn't designate them, but they are in fact controlled by